I'd now like to introduce Mary Sheridan, who has responsibility for provider governance and risk. And Mary is going to speak, first of all, about the due diligence process. Thanks, Mary.
Okay, so bear with me now while I see, can I share my screen? I take it you can all see that? Excellent. So, thanks, Jim. So imagine that you're in the business of approving houses to ensure that they are built correctly and to a high standard, and that they are safe to live in, but you've only the authority to check the outside walls and the interior decor, and you have no authority to check the electrics and the foundations of the house. This is the situation that QQI is currently in. QQI, like its predecessor bodies, has the legal authority to approve quality assurance procedures proposed by a provider and to validate programs submitted by those providers following approval of their quality assurance procedures. However, to date, QQI has not had the legal authority to examine the business that underpins the quality assurance procedures and the program delivery of the provider. This has proven to be a significant shortcoming, and that one that has impacted negatively on learners, providers, and the entire education and training sector. The new ministerial regulations to be introduced will give QQI the legal authority to check the business that underpins the educational provision of providers. Over the next 15 minutes, I will outline the proposed criteria and what these regulations will mean for you and your business, and in addition, how they will benefit learners, English language education in particular, and the wider education and training sector in general, through ensuring that the business structure and financial status of each provider supports the delivery of a quality product and consistent with the requirements of the legislation. The current gap in the oversight of providers by QQI has impacted negatively on learners and the sector over the years, where providers have closed or discontinued validated programs midstream. The damage caused to the education sector by these events has been significant. The new sections 29A, B and C of the 2012 Act provide for ministerial regulations that identify criteria that should give reasonable assurance to QQI that a provider has capacity and capability to implement quality assurance procedures and to provide programs of education and training consistent with the Act. What will this mean for you and your business? Well, private providers, including providers of English language education that intend to seek authorization to use the International Education Mark, will be required to meet these criteria concerning governance, finance, and compliance with the law. This will in turn give QQI reasonable assurance that you have the capacity and capability to implement robust quality assurance procedures and to provide coherent programs of education. The aim is to ensure that only providers with sufficient financial resources, sound business practices, and a genuine capacity and commitment to meet learners' needs will secure state recognition for the education and training provision that they offer. Parallel arrangements are already in place for publicly funded providers. These providers are subjected to a range of requirements under their own legislation and under the Department of Public Enterprise and Reform's Code of Practice for the Governance of State Bodies. The new regulations provide for three broad categories of criteria. The first category relates to criteria as to the provider being a fit and proper person to provide programs of education and training, including English language education. The second category concerns criteria related to the legal personality of a provider, the adequacy of financial resources to ensure the viability of the business, and arrangements to ensure good corporate governance. The third category of criteria are related to compliance with employment obligations, including sectoral employment orders. Now, from these three broad categories, 14 draft criteria have been identified. These criteria, together with supporting guidelines, are currently being considered by an expert advisory group for comprehensiveness and adequacy, and from your perspective, also very important, to ensure that they are fit for purpose and not unnecessarily cumbersome. The guidelines that accompany these criteria identify the documentation and information that will be required by QQI from providers in respect of each criterion in order to ensure that QQI may assess if a particular criterion has been met. The information and documentation required from you to demonstrate compliance with the criteria should largely be readily available to you and used by you for other regulatory and financial purposes. It is intended that the demonstration of compliance with the criteria will not impose a significant additional burden to you and to providers. QQI's providers currently range from small owner-managed enterprises to larger enterprises that are part of a group structure, and therefore size and uniqueness of business will not impact on the ability of QQI to engage with all providers. So what are the specific areas that are covered by the 14 criteria which are currently being considered by the expert advisory group? And what will you need to do to demonstrate that you satisfy these? So beginning with the first 7 criteria, you will note that there is nothing unusual in these. These criteria relate to governance structures, management structures, human resources, the business plan, fit and proper person, financial resources, and financial controls. I will take you through a number of these and list the information or evidence required from you in order to demonstrate that you satisfy the criteria. So beginning with the governance structures. In determining if this criterion has been met by a provider, the following documentation will be required. So the registered name of a provider, the name of your legal entity, or the trading name of the company, if relevant, a copy of your constitution, ownership details, your shareholders, your directors, details of influential persons and decision makers, shareholdings held in other companies, the locations of your business, CRO returns for the previous 3 years, your corporate governance policy, a high-level organisational chart, including names, the group structure if relevant, details of your legal representatives, your accountants, your auditors, and other financial advisors. So taking a second example, human resources. In determining if this criterion is met by a provider, QQI may seek the following documentation. So details of your staff, their curriculum vitae, the nature and extent of employment contracts, the actual employment contracts, staff turnover details, staff costs, projected changes to staff costs over the next 5 years. Moving on to fit and proper person. In this context, we're looking at fit and proper to provide programs of education and training. The provision of education and training to learners includes a moral, legal, and financial responsibility to learners, potential learners, and to the state. This criterion, if met, should satisfy QQI that the personnel with control of the providers are fit and proper persons to assume this responsibility. So fit and proper persons basically applies as follows. Where a provider is a company, it will apply to every director, shareholder, shadow director, decision maker, and person of influence. If a provider is a partnership, it will apply to every partner. But in all cases, it will apply to any person employed by a provider whose duties include making decisions that could affect the management of the provider. The key thing is that all individuals with decision-making powers must satisfy the same criteria. And in this context, matters to be considered by QQI would include any convictions registered against a person, their nature, the gravity of the offence, the time elapsed since the offence, current involvement in criminal procedures, any adverse findings in a court or a tribunal in relation to employment law in Ireland or in any other jurisdiction, bankruptcy, personal insolvency, or entry into any arrangement with one or more creditors, the right to live and work in the state, whether the person has been disqualified from managing a company or acting as a director, whether the person has outstanding debts to the state or QQI. So now moving forward to the next 7 areas. Here we're looking at legal structure and location, employment law, marketing, learner information under Section 67, tax compliance, Gdpr, and the provision of accurate and up-to-date documentation. Again, you will note that there is nothing usual in any of these criteria. And briefly looking through these, in respect of the legal structure and location, QQI must be satisfied that the provider is legally established and that it has a significant presence in Ireland or in a member state of the EU. All providers should have sufficient connection and commitment to the state if they are to engage with QQI. Providers must be accountable administratively and judicially in this jurisdiction. And if in determining if this criterion is met, QQI will look for proof of residence or incorporation, the extent and the duration of the provider's operations in the state or in a member state of the EU, and relevant tax returns. We'll move on then to tax compliance, and that's relatively straightforward. In determining if a provider satisfies this criterion, QQI will look for tax returns from the Irish Revenue Commissioners, or if the provider operates in another jurisdiction, from the tax authorities in that jurisdiction. Moving on to compliance with GDPR. QQI will assess the suitability and efficacy of the provider's data protection policy, the identity and qualifications, expertise and experience of your data protection officer, the suitability and efficacy of policies and agreements in relation to processing of personal data by you or on your behalf, and any third-party processing agreements that you have in relation to the processing of personal data that you hold. It should be clear to you that you are likely to have the information that will be requested from you in the context of the due diligence assessments. So what will the due diligence process look like? QQI plans to develop an online interactive form or process which will set out the information and documentation required from all providers. The online form will be designed to allow the provider to work on the form over time and to submit it when the required documentation and information has been gathered and the form is complete. Incomplete application forms will not be processed by QQI, and in circumstances where a provider submits an incomplete form, the provider may be given an opportunity to make an amended submission. However, QQI will also reserve the right to deem an incomplete application form an unsuccessful application. The onus will be on the provider to ensure that it provides the required documentation. As part of a due diligence assessment, QQI may visit the premises of a provider, and evidence gathered during these visits and any observations made may contribute to a final decision. The findings from the assessment of the documentation and the visit to your premises will be documented in a report which will include a decision and the reasons for that decision. The provider will have an opportunity to comment on the report or to provide additional information before the document is finalized. All decisions of QQI are published to ensure transparency, consistency, and fairness. It is important to note that there is a statutory obligation on providers to keep the information required up to date. So when changes are planned to any aspect of your business, for example, changes to ownership, to governance or management, QQI must be advised as soon as possible and as soon as the information becomes available. Failure to inform QQI of such changes in a timely manner will lead to an immediate due diligence assessment. As I wrap up this presentation, I hope that I've given you a sense of the new regulations, but more importantly, how they will benefit your business, the experience of your learners, and the wider education and training sector. Equally, it should be clear that the evidence required by you to demonstrate that you satisfy the criteria should be readily available to you. Like other aspects of the 2019 amending legislation, the regulations which underpin the due diligence assessments of providers will protect the interest of learners and providers across the entire education and training sector. The public interest is served by ensuring that QQI only engages with those providers that have appropriate financial capacity, governance structures, management and control structures, and are compliant with their legal requirements. In addition, the regulations will support the maintenance and delivery of a quality educational product, which will enhance the reputation of the sector both at home and abroad.